So what is an asset protection trust and how does it work? Imagine this, you spend your life building wealth, your business, your home, your investments, and then one day, boom, a lawsuit, and now someone you've never met is trying to take everything you've earned. But what if I told you there's a legal tool that can make your assets nearly untouchable, like putting your money in a legal fortress? It's called an asset protection trust. And if you're not using one yet, you'll want to stick around because today I'm going to show you exactly how they work and why they're a lawsuit's worst nightmare. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners, a nationwide firm, and I've been in this field for 34 years. And for nearly 30 of those, I've been setting up more Cook Islands trusts than anyone else in the world. And not one of them, zero, has ever been breached by a creditor. So if you're serious about keeping what's yours, click that subscribe button if you haven't. I post real strategies that high net worth people use to stay bulletproof from lawsuits. Let's dive in. So what is an asset protection trust? An asset protection trust, or APT, is a special kind of irrevocable trust designed to do one thing really, really well: shield your assets from creditors, lawsuits, divorces, and other legal attacks. And when I say shield, I mean if a judge pounds their gavel and says, pay up, your trust can say, sorry, Your Honor, this isn't theirs anymore. It's legal, effective, and when done properly, it's one of the most powerful tools in the financial world. So let's start by breaking down the people and parts involved, the key terms and roles in an asset protection trust. So before we build the vault, we need to understand the parts. So here are the key roles of any asset protection trust. First of all, the settlor, aka the grantor, the person who creates the trust and funds it. In other words, the one who calls our office from anywhere in the world and has us set up a trust. So think of setting up a trust like hiring a legal bodyguard for your money. Party number two is the trustee company. The trustee company is the person or company that manages the trust assets. In an offshore trust, the trustee is usually a licensed, bonded law firm in the trust jurisdiction. They follow the rules in the trust agreement and the laws of that country, and they're strictly regulated by the regulators in that jurisdiction. Okay, the next position is the custodian, or the protector. This is your watchdog. It's an optional position that can fire the trustee, veto their decisions, or replace them if needed. Now, ideally, this is a professional position, a professional protector that's outside of your jurisdiction that isn't subject to your local court. So we often provide that position with one of our offshore companies that U.S. courts don't have jurisdiction over. Next are the beneficiaries. Now, this is the person or the people who can benefit from the trust. Like you, for example, if you call to have us set up a trust, you can also be the beneficiary of the trust in an asset protection trust. There's another kind of trust we'll talk about, but asset protection trust, you can be the settlor and the beneficiary, and you can benefit from it like receiving distributions or inheritance. And in many cases, that includes you. And yep, like I said, you can still benefit from the trust even if you don't control it directly. Next is irrevocable. That means that once you set it up, you can't easily yank assets at a whim when there's legal duress. Initially you can, because we put an LLC inside. We'll talk about that in a bit. And that's the secret sauce, because if you could do it directly when legal duress strikes, then so could your creditor or the judge. And if you couldn't, the judge couldn't. So that's the legal firewall. So in other words, you can get the money out anytime because the trustee company law firm is on your side, but your enemy at law cannot. Okay, now here's a key concept: self-settled versus third-party trust. As promised, a third-party trust is where you set up a trust to benefit somebody else, like your kids. Pretty straightforward. But the game changer is the self-settled trust, where you set up the trust to protect yourself so you can be the settlor and the beneficiary. So you still own the assets essentially through the trust. And yes, that's legal too when done properly in the right jurisdiction. That's the key thing. Only a few jurisdictions allow you to be the settlor and beneficiary and still protect the assets inside. And it also has to be drafted properly. A self-settled asset protection trust is how high net worth individuals shield themselves from lawsuits, divorce, and liability. So let's break down how this works in practice. So let's say down here you don't have a trust and you have a $5 million portfolio. Okay, $5 million brokerage account in your own name. A lawsuit hits, the court freezes the account, game over. Now imagine this. You transfer that $5 million into an offshore trust. Legally, you no longer own the account directly, your trust does, and a court says, hand over the assets, but you say, I can't. I'm not the legal owner anymore. Your trust is. And if the trustee is offshore and not under your local court's jurisdiction, that's where it gets really interesting. Okay, let's start with the domestic asset protection trust. Let's start with a trust set up inside the U.S., for example. We do this for people all over the world, but let's say U.S., and they're often in states like Nevada, Delaware, or Alaska, or even Wyoming. And these are known as Domestic Asset Protection Trusts, or DAPTs. And here's what they usually require. A trust must be irrevocable. At least one trustee must be a resident of that state. The trust must hold some assets in that state usually. The settlor can also be a discretionary beneficiary. Sounds pretty good on paper, right? But here's the problem. The DAPT danger, judicial reciprocity. And what that means is, when there's a judgment in one state, the other state must enforce it. Let's say you live in California, but you set up a domestic asset protection trust in Nevada. You lose a lawsuit in California, the court demands your assets, and California says, hey, we don't care what Nevada law says. You're here, your assets are here, we're gonna get the assets, we demand you to bring them back, Mr. Trustee. And the trustee, because they're under the jurisdiction of the U.S. courts, do you think they're gonna give up their own money or yours? Do you think they're gonna sit in jail for contempt or give up your assets? I think we both know the answer, because they're under that judge's jurisdiction, because of judicial reciprocity. California courts can enforce their own rulings, even if that means busting through your Nevada trust. And if you think the state judges always respect the DAPT laws of other states, think again. And we've seen this happen repeatedly. A California judge ignores a Nevada trust. A New York judge disregards an Alaska or Wyoming trust, and bam, your assets are gone. So now that we know the domestic asset protection trust isn't all it's cracked up to be, what do we do? So next we'll talk about the offshore asset protection trust. So don't get me wrong, domestic asset protection trusts are better than nothing, but we see judges penetrate them left and right. So enter the offshore asset protection trust, and this is where things level up. We're talking about placing your assets into a trust based in a foreign country like the Cook Islands. Nevis or Belize, three of the most trusted jurisdictions in the world when it comes to offshore trusts, where U.S. court orders carry about as much weight as a snowball in a volcano. So let me say that again. When you're sued in the U.S., your offshore trustee of your offshore asset protection trust does not need to comply with that judgment. For your creditor to access those assets, they need to hire a lawyer in the foreign country, start a brand new trial there, pay hundreds of thousands of dollars in legal fees, fight through the nearly impossible odds, and here's why that really works. Why offshore trusts work so well. Let's take the Cook Islands, my personal favorite, and the one we've used for most of our clients, as well as Belize, which is a great choice if you're already in litigation. They don't recognize U.S. court judgments. Creditors must start over in Cook Islands courts. The plaintiff has to prove their case beyond a reasonable doubt, basically a criminal standard. That's a 97% to 3%, unlike the normal civil level of proof, which is a preponderance of the evidence. A preponderance of the evidence is like 51% versus 49%. So that's very, very hard to prove. That's why we've never seen one of our clients lose, and very, very, very rarely does the trial ever go to the Cook Islands, because your opponent can see it's too expensive. Next, they have a 1 to 2 year statute of limitations on fraudulent transfer. After that, it's too late. And even if they do beat the clock, we've never seen anybody win. And remember, I've been setting up trusts in the Cook Islands for almost 30 years. Our firm has established more Cook Islands trusts than any firm in the world. And not one, zero, has ever been pierced by a creditor. So this is not hype. That's a track record. Okay, now how we structure offshore trusts for clients. Now you may be wondering, well, if I don't control the trust, how do I access my money? And here's how we solve that. We set up a Cook Islands trust, and inside of it, we create a Cook Islands LLC. So 100% of the membership interest in the Cook Islands LLC is held by the offshore trust. Now you're the manager of that LLC while the waters are calm. You are the signatory in the bank account. You can trade your stock. So in other words, the trust itself doesn't have the bank account. The LLC has the bank account, and you're the manager of that LLC. So when a lawsuit strikes, that's when the armor plating can go on. The trustee can step in and they can remove you as manager usually, and they take over. Now you can still have bills paid on your behalf, log in online, do your stock trades like I do, even during legal trouble. I don't have legal trouble, but I like to practice what I preach, and I like to always be prepared if a lawsuit comes my way. That's why I have a Cook Islands Trust myself. So you get control while things are fine, you get asset protection when the storm hits. So that's the hybrid weapon we've built for thousands of clients. Now there's another type of trust we set up. It's called the trigger trust. That's a U.S. trust when the waters are calm, and we pull the trigger and turn it into an offshore trust when things start to heat up. And that trigger trust is our trademark. We're the only one that can legally set up a trigger trust because we own the term. Okay, other benefits of offshore trust. So let's hit a few more reasons why offshore beats domestic every time. First of all, short statute of limitations. In the Cook Islands, assets are protected right away. Creditors only have 1 to 2 years to file a fraudulent transfer claim in the Cook Islands, and we've never seen a creditor win ever. In Belize, there's no statute of limitations because they don't allow it at all. Number 2, privacy. Offshore trusts protect your name. They're not searchable in the public records in the U.S. or the foreign public records. So creditors won't even know that you own it, if anything, unless you're forced to tell them. Next, own an LLC inside of the trust. That LLC can hold your brokerage account, crypto, gold, you name it. We also record liens against your property, payable to a third-party lender if needed, and the proceeds of that loan can go into your offshore trust. So even your domestic equity is stripped out of your real estate, and we can also record liens, UCC1 liens against business interests and so on, and suck all the value out and put that offshore. So as a manager, you can use it like any other company until the threat appears. Number 4, estate planning. So the trusts we set up, the offshore trusts, have no rule against perpetuities. That means they can last indefinitely, transferring your wealth to your children, your grandchildren, even your great-grandchildren. Now, here's some common misconceptions I want to cover, so let's clear up a few myths. First of all, asset protection trusts are for shady people. False. Our clients include doctors, entrepreneurs, real estate investors, and business owners who've done everything right, but live in a lawsuit-happy world. I mean, if we get a shady character, they won't be our client. So we don't accept every client if they're doing something shady. They're not going to be our client. Trustee won't accept them. Banks won't accept them. So we're very selective about who we allow into our law firm. Next, if you're sued, it's too late. Well, not necessarily. While early is always better, we've protected clients mid-lawsuit using tools like equity stripping, layered LLCs, combined with international trusts. Next misconception, offshore equals illegal. Absolutely not. Offshore trusts are 100% legal when properly disclosed. We do everything by the book. FATCA compliant, IRS compliant, and ethical. Okay, let's give a real example here. A doctor saved by an offshore trust. Give you a quick story. A surgeon came to us after being falsely accused of malpractice. He was looking at a $6 million lawsuit, savings, real estate, investment accounts. So we set up a Cook Islands trust with a Cook Islands LLC inside. He remained the manager of the LLC, and he kept using his assets freely. So when the lawsuit escalated, we triggered the trust. The offshore trustee stepped in, removed him as LLC manager, and legally locked down the assets. The plaintiff's lawyers tried to attack the trust, but couldn't because they couldn't get jurisdiction. They backed off. Settlement, pennies on the dollar. He kept everything. So who should set one up? Here's the truth. If your net worth is over $500,000, if you're a business owner, if you own rental properties, if you're a doctor, attorney, CFO, or other high-risk profession, or if you simply want to pass down wealth safely. So if you have significant assets, you're a target and you need protection. So here's how to get started. If you're ready to protect your wealth, you can go ahead and go here. For your next step, go to assetprotectionplanners.com, and you can get a whole lot of free information there. You can call us directly at 954-400-1050. Our team has been doing this for decades. We'll walk you through the best plan for your specific situation. We have employees that have been here for 15, 18, 20 years, long-term employees, attorneys, experts on staff. So whether you need to protect your home, your business, or your entire portfolio, we've got the blueprint. So what is an asset protection trust? It's your legal vault, your invisible shield, your lawsuit insurance without paying the monthly premium. So in a world where lawsuits are a weapon of choice, it's the best defense money can buy. I'm the business guy with Asset Protection Planners, and thanks for watching. And remember, it's not what you make, it's what you keep.